My name is Kelly Trudell. I'm the firm's business development director, and I'm pleased to welcome everybody to our two-day virtual seminar. Be sure we wish we were at the Castleton, but this will do for now. Today, we have nearly 500 people registered and lots of information to share with you. But first, just a few housekeeping items. This session will run from 8:30 to 10:30 today, as well as on Thursday from 8:30 to 10:30. We encourage you, though, to check your registration. If you registered for today, you also need to register for Thursday. Also complimentary, but it is a different Zoom link, so please check. This program has been approved for 2 credits, and that information is provided at the end of the session on one of the slides. We encourage questions throughout the program. However, the current presenter will answer the question during that session. So if you have a question during one presentation, please use the tab at the bottom of your screen and type questions that will be addressed at the conclusion of each presenter's slides. We also have an evaluation at the end, and we really encourage you to complete the eval, which allows us to understand what information is helpful and how we can improve going forward. We're really excited to start today, and now I'd like to welcome Jim Reedy, the co-chair of the Employment Law Group here at Sheehan Finney. Thank you for joining us.
Well, good morning, everyone. Thank you, Kelly. We're really excited that you folks are here today, and for our 33rd annual. Can't believe, but a lot's gone on in the last year, and so we're doing this time with the virtual seminar, and hopefully it's our last big virtual seminar. As Kelly said, we'll be back in person next year. Is that it's 2 parts. So today we're going to talk about sort of looking back, the experiences of the last year, COVID and COVID-related workplace issues, and then this Thursday, the 27th, we're going to look at sort of the post-COVID era. But before we get started, we have a guest appearance here, and we're going to start that now.
It appears we're having some technical challenges with the video.
Is there no sound?
No sound.
Oh.
Merging and coming back to hopefully more.
Sure. Well, look, I think what we're talking about here today will work.
Thanks for your patience. We're going to restart the video. Thank you.
Governor, thank you so much for being here today.
Absolutely.
Really appreciate it.
Thank you for coming in. I don't get to actually sit on a one-on-one interview. This is one of the first ones I've done in a while, so it's very apropos.
It's refreshing not to wear a mask. It's great to have the vaccine. Brighter days ahead. We've said before that the pandemic's not going to come to a hard stop. It's going to be a gradual.
Yeah.
But as we're emerging now from that, what changes remain for the Granite State as we're now emerging and coming back to hopefully normal?
Sure. Well, look, I think what we're talking about here today will work. I mean, that's one of the biggest issues, the fact that at this time last year, we had about a 17% unemployment rate. Right now, we're back to pretty much pre-pandemic levels, just below 3%. Everyone is putting out every dollar they can possibly put out for any employee they find in every industry. That's a very good thing, in terms of a strong economy, but it's also worrisome because you want to make sure folks are incentivized back into that workforce.
Recently, you ended the state mandatory masking or the mask mandate, and now we've shifted focus to best practices, and that is welcome, at least to many employers in that regard. The change in the requirement for unemployment benefits,
Yes.
you have to look for a job.
Great question. We early on in the pandemic, we realized that we're going to be a lot of folks on unemployment, and if they had to go look for work that either A, wasn't there, or B, they had to go and actually have a one-on-one interview, but they didn't feel safe doing so, that was going to be a bridge too far for folks, and we understood that. So we were one of the first states in the country to really drastically change how we did unemployment. We provided an unemployment fund, and incentive for folks, back before even the federal government was doing it. We opened up our eligibility. And in doing that, we also got rid of the work requirement. Now our economy is coming back. People are vaccinated. They can do it safely and easily. So just I would say, yeah, we're going back to the old system. We're not adding more burdens. We're just going back to the old system where if you want unemployment, you got to go look for a job.
So just a little snippet of the interview with the governor, and if that confirms nothing else, which is that we've made great progress, and it also confirms that I have a face for radio. So welcome again, everyone. I think just so excited to be here. As Kelly said, gosh, almost 500 people registered for this session and also for our session on Thursday. And that's great. And it also shows that there's a lot of information out there and we've got a lot to share. As you've probably seen from the program guide, I'm going to do my annual sort of smorgasbord review of recent developments in labor and employment law, and then turn it over to Megan Carrier, who's going to talk about something you've all had to deal with, which is remote workers and managing remote accommodations in the workplace, not only looking back, but looking forward, which is going to be equally important. Followed then by JP Harris. A lot of you have followed JP in the last couple of years in his work on data security, and but especially with regard to data security for those working remotely, whether it's in a Starbucks coffee shop or otherwise, and making certain that your confidential, proprietary, and other information is protected, and your data is protected from data theft. And related to that, then we've got Michael Lambert closing out today's session, talking about protecting your confidential information and trade secrets. So not just your data, but your customer lists, your confidential relationships and the like. So, and that's today's session. Next, on this next Thursday, the next session, it's going to be Karen Whitley going to talk about the American Rescue Plan, something that you folks have had to deal with recently. Liz Bailey talking about labor relations. So not just the employment side, but the labor side of things and the changes that we've seen so far that we're likely to see in the next couple of years. Brian Bouchard's going to talk about something that long haul COVID, masking, workers' compensation, and OSHA issues. And those have also certainly come up during COVID and in the post-COVID era. And then we close out with a talk about upcoming legislation, both in Congress and in here in Concord. So let's get started and going to just sort of go through, so again, recent developments in labor and employment law. So no question, by all accounts, 2020 was a year like none other in modern times, both with the highs and lows. Because if you look at how we started off the year, last January, the economy was humming along pretty well, record low unemployment numbers, and it seemingly that did change overnight. We went to a high in New Hampshire of 17 or 18% unemployment. Thankfully, in just over a year, we're back down to about 2.3%. And all you HR professionals out there, you know how difficult it is to find the right person for the job these days. But as the governor said, brighter days ahead. So there's no question that the last year has been, and I mean, we don't want to use the overused terms like unprecedented times, but businesses of all types and sizes truly did struggle to keep the doors open, keep employees safe, which was the paramount responsibility of the HR professionals, adapt to remote work, and Megan will talk more about that, and yes, comply with state and federal guidelines. As the virus evolved, so did the guidance, and we're going to talk a bit about that because it's not over with. Similarly, while the pandemic is not going to come to a hard stop, similarly, a lot of these state and federal guidelines and laws, they're going to be with us for a while as we move on to the next, but there are still some issues to address. So, looking back in that last year, Congress and state governments managed to come together. We live in a time of great balkanization or political divide, no question about that, and that's truly unfortunate. At a time in which, however, there was truly a crisis in March and April of last year, both at the state legislatures and the governor's offices and at the federal level, both president and Congress seemed to come together for a period of time, put aside their political differences and come up with relief packages. And those were certainly very welcome. And they came fast and furious, starting with last April. And we're going to talk a little bit about that because, again, there's still some compliance issues associated with that. Now that 2020 truly is, and we like to say in the rear view, and the FDA has approved 3 and perhaps even 4 with AstraZeneca vaccines, it's fair to say that hopefully the light truly is at the end of the tunnel. And with the new administration in both in Washington and also with the new composition of the legislature in Concord, there are lots of issues to address, and there certainly has been a change since last year. So let's briefly review those, and I think that address what we've seen so far. And I'd like to say again, we'll take it slowly because truly HR professionals have truly you've shouldered a great deal in the last year. In addition to everything else you normally do, from payroll to benefits to onboarding and compliance with an increasing number of federal and state laws and regulations, you had to immediately shift almost overnight to shutting your workplace down, getting your employees either furloughed or working remotely, and dealing with all the issues associated with that. And then also at the same time, following all the safety protocols for screening for the employees that remain. It's a lot. So we'll take it slowly. So the highs and lows of the last year, the FFCRA, that was adopted when? In 1 week, in March of last year, 1 week. When have you ever heard of federal legislation being drafted and adopted in 1 week? And so effectively, that means that, there were some difficulties with it. And thankfully, the U.S. Department of Labor issued its FAQs throughout the year, providing some additional guidance and responding to questions. But the Family First Response Act, as we know, provided 2 things: emergency sick leave and for covered employers with fewer than 500 employees, and emergency family leave. But it wasn't family and medical leave. It was different if a child's daycare or school were closed down. Then the parent could take time off, and that time was paid, and various rates and so on. But the employer got the tax credit, the payroll tax credit later. It was a lagging indicator, but it was still helpful. The CARES Act, the Coronavirus Aid, Relief, and Economic Securities Act, was sort of 2 parts, as you know. It was both augmenting unemployment benefits, providing up to as much as $600 on top of what the state would provide, and the payroll protection program, which was to restore employees back to the payroll and off of assistance. And those were either low interest loans or totally forgiven. And that is still in the process, as we're going to discuss in a minute, of being reconciled by the IRS and the Small Business Administration. At the same time, recreational marijuana is still sort of gaining traction in the U.S. Now, Arizona, Montana. Who would have thought Montana and South Dakota would have gotten on the pot train? But Arizona, Montana, New Jersey, and South Dakota now have legalized recreational marijuana. Now, as many as 40 states in the U.S. have legalized marijuana in one form or another. And if that wasn't sort of interesting enough, how about this one? During all of this going on last year, but in that last election cycle, drugs, meaning possessing heroin, cocaine, methamphetamine, and other drugs for personal use, is no longer a criminal offense in the state of Oregon. Yeah, that's the response from a lot of people in that regard. So let's go to some of these agency issues, the agency enforcement issues from 2020. Now, the interesting thing in that regard, I think, is that most of the agencies, state and federal, seem to come together, not in that regard, but for a unified purpose in what they were going to do with regard to employers. Now, the U.S. Department of Labor, the New Hampshire Department of Labor, rather, still did their inspections, but they were all virtual. In fact, they are still completely virtual. They have not gone back to the office. They did have field inspectors out in the field, but largely their inspections were done via email and phone calls. 847 inspections, 1.6 million assessed, and 376,000 collected. What does that tell you? A fraction of what was assessed was collected. And effectively, that message is the inspections were down and the collections were down. They were giving employers a break effectively during, again, a national or an international pandemic. The U.S. Department of Labor, again, they gave really helpful guidance with regard to the FFCRA in particular. And that was their major focus of the last year. However, as the year changed, and Brian's going to talk about this in Thursday's session, their focus went back to wage and hour issues and to the other side of the OSHA, of the U.S. Department of Labor House, OSHA. They really ramped up their inspections and their safety inspections. But the U.S. Department of Labor did have, as the year closed out and as it transitioned into 2021, they looked at the joint employer rule and they clarified their rule with regard to independent contractors. That's because under the last administration, there was a new rule with regard to proposed rule with regard to joint employers, basically making it difficult to show that two entities acting in concert, acting together, could be deemed to be one employer for purposes of liability under federal wage law. And also with regard to independent contractors, it was basically, again, making it easier to determine someone was an independent contractor as opposed to an employee. The joint employer rule was vacated, and the independent contractor rule has effectively been revisited. And some would say it's going back to the Obama era. It's actually going back to the Bush era for purposes of economic realities. EEOC, as we know, during the last administration, had postponed its pay equity collection after the 2017 collection of data with regard to pay equity with regard to gender pay or pay between the genders. But they're now studying, EEOC is now studying that information, and by the end of this year, they're going to complete their study and decide what they do next with regard to EEO2 data collection. In the meantime, again, during the crisis, what they did was they issued very helpful information with regard to, could you ask someone if they've been vaccinated? Can you mandate the vaccine? And so on. And while at the same time, they issued some warnings with regard to discrimination in the workplace. The IRS stimulus checks, lots of them, and some more with the American Recovery Plan, or Rescue Plan rather, and PPP loans, which they're working with the Small Business Administration on. Very helpful for employers. OSHA, they relaxed their drug testing guidelines because of remote work and other issues, and even with DOT truck drivers, but they also focused more on their safety audits in the last year. And the National Labor Relations Board, under the last administration, restored the employer's right to restrict access to email. Usually there's a flip between administrations, especially if it's from one party to the other, being more employer-friendly, being more employee-friendly. Liz is going to talk about that. We haven't seen a dramatic change yet, but change certainly could be coming. Workplace legislation, very quickly, things that stalled in Congress, changes to the Age Discrimination Employment Act. On Thursday, I'll talk more about that. The same is true with the Paycheck Fairness Act, which is pay equity issues, the Working Families Act, which is dealing with comp time available to private sector employers. FMLA Modernization Act would be to lower the threshold from 50 to 25 employees. But in addition to that, allowing parents and grandparents to attend to school functions and other of the children's activities, in addition to serious health condition of the FMLA. Healthy Families Act, mandating sick leave and protecting independent contractors from discrimination. What that was basically was to provide employment-related protection to independent contractors, which is sort of a strange mix of concepts. All of that stalled in the last Congress. Similarly, in New Hampshire last year, when you had a Democratic House and Senate and a Republican governor, there wasn't a lot of bipartisanship in that regard, and not a lot went through. Proposed changes to the minimum wage up to as much as $12 an hour, limiting access to criminal records, mandatory payment of vacation time, paid family leave, which was a concept that's kicked around for a couple of years in New Hampshire, pay equity, wage data being collected on the state level, drug tests and marijuana use being, again, gone back and forth with regard to, again, New Hampshire has approved medical marijuana, and mandatory paid sick leave, all stalled in New Hampshire. Workplace guide legislation that was sort of went under the radar in New Hampshire was notice in advance of a work schedule changes that employers would have been required to give notice 14 days in advance of a schedule change. Think of how awkward and how difficult that would be for employers. And that was, again, the resistance that came up. That was proposed. It went under the radar and went to study committee. Greater limits on non-competes. There are already limits, not as much as they are in Massachusetts, but there are limits in New Hampshire, and those continue to be narrowing. Securing space for nursing mothers, that is one that's on the agenda again for this year, both on the state and federal level, in addition to what the changes were under the ACA and the FLSA in recent years. Changes to criminal checks on school employees, actually enhancing those checks. And then an employer COVID-19 immunity bill, which was in the last session, but it is back again in this session. Some cases that went before the US Supreme Court. Perhaps the most important was the Bostock decision, which was the Supreme Court basically saying that LGBTQ, and in particular with regard to transgender rights, are protected as sex under the definition of Title VII, which is the federal discrimination law. The on-call case of a few years ago with sexual orientation, actually as much as 10 years ago, challenging Congress to adopt something. Congress still has not adopted that, and changing and actually putting LGBTQI rights in Title VII. But it could be the Bostock is the reason for that change coming along. Our Lady of Guadalupe, the Morrissey case, that was the ministerial exception to discrimination claims. Basically, that someone who works in a church or school, religious school, was exempt from federal discrimination claims. And then the ACA exemption for the Little Sisters of the Poor with regard to contraception in their healthcare plan for their employees. Those weren't necessarily all that surprising, but those were the workplace issues of the last session. There are a few in this new session of the Supreme Court. National Labor Relations Board, again, under the last administration, greater confidentiality in workplace investigations, and revisited a standard for offensive outbursts in the workplace, basically, that the employer could step in if there were, even though someone mentioned terms and conditions of employment, that if they were using vulgar and offensive terms, they could be disciplined. The U.S. Department of Labor, in addition to all the other things they did with regard to COVID, recommended investment in a apprenticeship program, federal apprenticeship program, or national apprenticeship program, and they sought input on the FMLA forms, which was kind of comical, you think, in the height of a pandemic, asking for more input on the forms from employers, and their focus, of course, was elsewhere. Freeze on non-immigrant visa processing happened in the last administration. That is changing under this administration. So let's pause here for a few poll questions. Poll number one: how well did your organization adjust to the state of emergency and stay-at-home orders last year? Option one: we freaked out like everyone else. It was rough. We shut down. We furloughed many employees. The next is we were able to transition nicely to remote work. And the last is we managed. It wasn't pretty, and we're still recovering. So you select one of those. Andrea's working on tabulation, but we should have quick results here. I always want to say this, and the survey says you're able to transition nicely to remote work. There you go, Megan. 58% of those that responded. Very nice. I'm surprised the freak out number wasn't higher, but there you go. Do we have a second poll question? Here we go. Would you say the FFCRA and CARES Act helped or hurt your organization in 2020? Helped means that you needed the money and the assistance. Hurt because compliance wasn't easy and it made staffing more difficult. Survey says helped, 65%, but it's interesting to see 35% said it hurt. And I think that was related to the issues with regard to the CARES Act and the amount of money that was available for those sort of augmenting unemployment benefits, but also the issues with the PPP loans and compliance with those, and the FFCRA. Yeah. Poll question 3. Now that we're early in 2021 and the pandemic seems to finally, thankfully, be waning, what are your greatest workplace challenges going forward? 1 is filling vacant positions. 2 is still figuring out your PPP obligations if you received one of those. Complying with the American Rescue Plan, deciding on what to do about masks, or updating your workplace policies given the new normal in the workplace. Survey says, wow, look at that, 67%. And again, the governor talked about 2.3% unemployment from a high of 16 or 17%. I'm not surprised to see that at all, filling vacant positions. So remind you folks to post your jobs to New Hampshire LaborNet as well, because it's free. We're trying to get as many people working as possible. Thank you, Andrea. Back to our show. Okay, so where are we now? There are a few workplace cases pending before the Supreme Court. President Biden has already taken steps through executive action to take certain steps with regard to workplace policies in a new direction. Congress now has a Democratic majority in both houses, and in New Hampshire, you have a Republican majority in both houses, along with the governor's office. So what that means is, on a federal level, things are passing through based on a certain agenda, and similarly on a different agenda, related but different agenda here in New Hampshire. So what we're seeing already for purposes of the Biden administration initiatives, increase to the minimum wage. We saw that with federal contractors, change in EEOC's priorities, their 5-year strategic plan, a focus on pay equity issues and regulations are reactivated with regard to that. LGBTQ rights added to Title VII, and again, they're encouraging Congress to do that. Religious exemptions to be tested, the limits of those, how far they can be extended in the exemptions, more accommodations for pregnant workers, updates to age discrimination laws, looking to go back to a sort of a mixed motive as opposed to age must be the sole reason for the discrimination, and updates and changes to immigration laws after the 4-year stall. EEOC guidance on, now that the vaccines are here, EEOC guidance on mandates and inquiries was actually very helpful back in December and continues to be helpful with regard to whether or not you can mandate your employees to get the vaccine, job-related and consistent with business necessity, and inquiries. Are you vaccinated? But of course, you have to be careful about how far you ask. Why, you don't ask, why is it? Do you have a hidden medical condition we don't know about, and so on. So that guidance, very helpful, and it continues to be. In fact, when you have more employees unmasked and those that are masked, you're going to see the distinctions even greater than before. And so HR being careful in that regard as far as managing that. The other thing is managing workplace accommodations with regard to the opt-outs from the vaccine. And can you offer incentives? And the EEOC says yes, under their same wellness standard, you can. You just can't penalize someone for not getting the vaccine. And then, of course, we'll see more changes to mask policies. We're seeing them already in the various states, but also the localities, and travel restrictions and remote work and other policies. Lots coming along as the vaccines have been a bit of a game changer. The mask surprise 2 weeks ago on the CDC sort of did its, not really course reversal, but a course change, fairly abrupt with regard to outdoor use of masks and even indoor use when you have the vaccinated, the fully vaccinated. But the question is, can you ask for proof? And will there be such things as vaccine passports? Hopefully not. But what proof can you ask? And again, the EEOC says you can ask for proof. But what are you going to do if the employer refuses, or the employee is not vaccinated but still doesn't wear a mask, and so on? So you've got state guidance, but you also have local ordinances, and you may have seen this as you're driving around New Hampshire and otherwise, where some communities are still saying, well, the governor said that, we still require it. And of course, in businesses, you may walk into a store where they still require masks and so on. And what the governor said was, we're not doing away with masks. We're going from a state mandate to employers, you adopt your own best practices. The American Rescue Plan, I mentioned that very quickly. I think, again, Karen's going to do a deep dive into this on Thursday, but it was the latest attempt at boosting the economy, but also assisting those that needed help. The biggest issue there is really going to be from April to September, the COBRA premiums for displaced workers and the employer credit for that. So if you're terminating an employee, unless it's for gross misconduct, you're going to be paying their premium and getting a tax credit later. And there are other elements as well, and one of them is the FFCRA tax credits are extended to the end of September. And FFCRA is now available for those who get the vaccine or recovering from the vaccine. Again, Karen's going to deal with this in greater detail on Thursday. And again, augmenting unemployment benefits, not the 600 as before, but it's 300. And there was, of course, a tussle in Congress over that. But some states now are breaking ranks in that regard, and whether or not they're going to accept the federal money. The governor in New Hampshire has said that they're not going to be accepting it further. They're going to require that people go back to work, or at least search for a job in order to get unemployment benefits. New Secretary of Labor is former Mayor of Boston, Marty Walsh. He's looking to roll back again the regulations on joint employment from the Trump era, changing the standard with regard to independent contractors, going back to the economic realities test. And this one, if you have a US DOL audit going on right now, pre-litigation liquidated damages are a possibility. Liquidated damages being up to double the amount of the civil penalties they might assess, as a way in which to basically to penalize an employer or to get your attention, settle the matter quickly. The NLRA, the National Labor Relations Act, or the National Labor Relations Board, Liz Bailey's going to cover this on Thursday, but shifting back likely to a more pro-employee or pro-labor position. But so far, we haven't seen that. There've actually been a few pro-employer decisions or preserving employer rights under this new National Labor Relations Board. The IRS, again, looking at the latest round of PPP and audits, and reconciling whether it's a low interest loan or a forgiveness, still in the process, especially for the larger PPP loans. And EEOC, after the COVID guidance, is now revisiting their strategic 5-year strategic plan. The COVID immunity bill in New Hampshire is back as a priority for employers, and the governor is pushing that. He's also pushing investment in local education and workplace training. Also, workforce housing, making it affordable housing available for workers in New Hampshire. Paid sick leave and PTO cash outs are still on the agenda from the legislature. Increase to the minimum wage might be slower than certainly you might see on a federal level, if at all. Right to work, where you cannot require union membership as a condition of employment, is going to be back to the House in June. And the controversial House Bill 544, which was divisive language, which was an answer to critical race theory in training, workplace training, and that will likely be defeated. Workplace safety issues, Brian's going to talk a bit about this on Thursday, but OSHA inspections absolutely on the rise. And I think we're going to see other issues like more vaccine and mask policies, perhaps looking at opt-out claims when people opt out and if they just said there's some sort of discrimination in the workplace, or even challenging incentives that employers may provide for people to come back to work or to get the vaccine. A couple of quick cases before the Supreme Court. One is with regard to employee computer use, and if it's being accessed for proper reasons, but then improper use, whether or not that is a violation of federal law. ACA challenges to the individual mandate because of, with the individual mandate being eliminated in the last administration, whether the ACA itself now is going to falter, because that was the funding source that was approved by the Supreme Court, and then the authority of an arbitrator. So a couple of, certainly one big case, and then some lesser cases before the Supreme Court. So hopefully during the rest of 2021, we'll see the end of the pandemic, the acknowledgement by regulators that there's enormous burden on HR and to give us a break. Better agency processing of discrimination claims so they don't languish as long as they do. Again, several of the agencies continue to be fully remote, and that can slow things down even further. More clarity with regard to PPP repayment obligations by employers that got those loans. FFCRA payroll credits being finalized in this year. Common sense applied to National Labor Relations Act rules. Liz, again, we'll talk about that. Hopefully, putting down sort of the political divide and more cooperation between the branches of government. And in our workplaces, more civil dialogue, and certainly within our communities as well. And of course, my favorite, the Red Sox and Patriots return to glory. So again, most of that's a wish list and not a prediction. There's no question during COVID, employers' focus was almost singular in that it was FFCRA compliance, managing remote work and furloughs, CARES Act, new safety policies and procedures, which will continue indefinitely, and addressing employee concerns and accommodations. Now, as we hopefully transition to a post-COVID workplace, while COVID is still with us, we've learned a great deal, and now it's time to start planning for the next steps of what could be, again, the post-COVID era. There's no question, never a dull day in HR, and that certainly will continue as we go forward. So hopefully you're ready. And I'll be available for questions. I don't want to run up against Megan's time. I'll look at those, and if we've got time afterwards, but otherwise, I think mine, again, is just an introduction and a warm-up for the true talent that is to follow. And I would like you to please welcome my partner and Megan Carrier, as she's going to talk about managing remote work and accommodations in the workplace. Megan.
Thanks, Jim, and good morning, everyone. As Jim mentioned, my name is Megan Carrier, and my presentation today relates to remote work accommodations. And my efforts to change, there we go. All right, so my goal with this presentation is to provide a brief overview of remote work accommodations in the pandemic and post-pandemic eras. We will be discussing the changing landscape of remote work requests and accommodations. Remote work is a required accommodation in the context of a disabled employee. Remote work that is unrelated to disability, which should be pursuant to a written company policy, and a number of other issues that arise as a result of remote work, which can get employers into hot water. Okay, we're going to start with a couple of survey questions. So the first question is, if you allowed your employees to work remotely in the last year, how many of your employees actually worked remotely? And the results look like, so it looks like for most people, 50 to 75% of their employees worked remotely. So surprising no one, it looks like a lot of people worked remotely last year. The second poll question. There we go. So the second poll question is, assuming you have required or will soon require employees to return to work, how many employees will still work remotely? Oh. And the results, less than I thought, actually. It looks like most people, it's only 1 to 10%. But for most of us, it does look like remote work will continue to be a reality as we move, hopefully, away from pandemic times. Okay, so remote work in the after times. Why are we talking about remote work? I'm willing to bet that many of you already know the answer to that, because many employers like you were forced to allow employees to work remotely as a result of the virus. And perhaps many of you are still in the process of doing that, or transitioning out of it. As employers begin to reopen their work sites, many are facing an influx of requests to start or continue working remotely. Employees are seeking to continue teleworking for a variety of reasons, including first, pandemic-related fears, which although hopefully as more and more people receive vaccinations, this will be less of an issue. For now, employees are still afraid of catching the virus in the workplace, particularly if they have an underlying medical condition that makes them more vulnerable to severe medical issues were that to transpire. Some are also afraid of exposing another member of their household to the virus, maybe a member of the household that, that has one of those medical conditions. And while things are improving, some employees are still facing difficulties associated with childcare and or caring for sick family members. For other employees, the desire to work remotely is less directly related to the virus and more related to productivity. Many feel that by avoiding a commute or avoiding interruptions that tend to arise in the office setting, they're able to get more done and to be more productive while they're working remotely. And they like to continue doing so on a full-time or a part-time basis. And in some cases, employers are in agreement with that assessment and willing to consider allowing remote work for certain employees. For other employees, it's just a matter of comfort. Maybe they're more productive at home, maybe they're not, but they enjoy working from their own space and avoiding the hassles associated with going to the office on a daily basis. Unfortunately, by forcing many of us to work remotely, regardless of whether we wanted to or whether our employers wanted us to, the pandemic has led many people to change their opinions with respect to remote work. Employers who previously viewed it as a drain on production may have found the opposite to be true. Before times beliefs that certain job duties required in-person work have been proven to be fully or partially incorrect. For all these reasons, employees and employers alike are reevaluating the concept of remote work, both in the context of disability-related accommodations and otherwise, and coming to varying conclusions regarding whether or not it's a good idea, whether it increases productivity or not. So now we have my third and final survey question, which is, regardless of, this question is based on the fact that regardless of all the reasons attitudes have been shifting in favor of remote work, it's not without its pitfalls. So what issues have you encountered with remote work accommodations? Okay, so it looks like a lot of different issues. We have equipment shortages and connection issues, managing productivity, resentment from in-office workers. Those seem to be the main three problems. So even if you have employees who are being productive working from home, there still are issues with it. And there are certainly reasons why you might want your employees back in the office. Okay. So remote work and the ADA. Employers are not generally required to allow employees to work remotely. In the context of COVID, that means that employers have no obligation to provide telework arrangements for employees who just have a general fear of catching the virus in the workplace. Maybe they're concerned about the fact that masks are becoming less prevalent, but if it's just a general fear, there really is no obligation to let them work remotely. But the ADA does provide an exception to this general rule in that employees with certain medical conditions may seek telework as a reasonable accommodation. An employee might seek that accommodation in the context of the virus. The CDC has actually published a list of medical conditions that may put certain employees at a higher risk for severe illness, or they may want to work from home just generally. Given the changing landscape of remote work, an employee who requested and was denied remote work as an accommodation in the before times may renew that request upon the employer's decision to reopen the office. And there may be some changes in the way that the employer evaluates those requests after having gone through the previous year. So as always, the first question to ask yourself when considering the impact of the ADA on your remote work considerations is whether or not it actually applies to your company. The ADA applies to employers who had 15 or more employees during 20 work weeks in either the current year or the previous calendar year. In the event the ADA applies to your company, you probably already know that under that law, employers are prohibited from discriminating against qualified individuals because of a disability and must provide a reasonable accommodation to individuals that cannot perform one or more essential functions of their position because of the known limitations associated with their disability. So reasonable accommodations. As you may already know, a reasonable accommodation is a change in the work or workplace that allows an individual with a disability to perform his or her job, all of the essential functions of his or her job. However, it's important to remember several things. First, employers are not required to provide an accommodation if doing so would cause an undue hardship on the business. An accommodation presents an undue hardship within the meaning of the ADA where it presents a significant difficulty or expense for the employer. Whether a particular accommodation creates an undue hardship is fact specific. It's a case-by-case evaluation looking at factors including the employer's operations and financial resources, the cost of the accommodation, and the impact the accommodation would have on the employer's operations. So pre-COVID, it was harder for an employer to deny an accommodation based solely on expense. As we all know, however, the pandemic has unfortunately had a negative financial impact on a wide variety of companies. Pursuant to EEOC guidance, it might be easier to show undue hardship based on circumstances of the pandemic if a requested accommodation, including remote work, is logistically or financially more difficult for the company. Second, and relatedly, and remember that the employer has the ultimate discretion to choose between effective accommodations and may choose a less expensive accommodation or an accommodation that's easier to provide so long as the accommodation enables the employee to perform the essential functions of the job. Finally, employers are not required to provide accommodations under the ADA to an employee who is not disabled based on the disability-related needs of a member of their household or another person with whom they associate. So the fact that an employee lives with an individual whose disability renders them high risk doesn't equate to a requirement that the employer allow the employee to work remotely as a reasonable accommodation under the ADA. So the interactive process is the balancing of proposed accommodations with potential undue hardship. And that requires employers and employees to engage in a process to determine the employee's limitations and the best way, if possible, that the employer can assist the employee in a way that allows the employee to continue completing all of the essential functions of his or her job. So what information can the employer ask for? You can ask whether the employee has a condition that qualifies as a disability under the ADA, which would be a physical or mental impairment that substantially limits one or more major life activities. You can ask what are the disability-related limitations. You can ask how the requested accommodation, in this case, remote work, would help the employee perform the essential functions of his or her job. And you can ask and discuss potential alternative accommodations that might achieve the same purpose in a way that is more workable from the perspective of the employer. So pre and post-pandemic attitudes relating to remote work are rather different. Pre-pandemic, the EEOC stated that telework would not be a reasonable accommodation where the employee's job required face-to-face interaction, coordination of work with other employees, or in-person interaction with outside colleagues, clients, or customers, or immediate access to documents or other information located only in the workplace. Pre-pandemic courts actually agreed, recognizing that many jobs require the kind of personal interaction and supervision that cannot be had in a home office situation. Before the pandemic, there was actually a general consensus among courts that regular work site attendance was an essential function of most jobs. To a certain extent, this remains true in the pandemic and post-pandemic world. A nurse cannot perform his or her job from home, nor can a sanitation worker or a cashier or a police officer or a firefighter. But what about traditional office jobs? We have learned that you can interact face-to-face with your colleagues without being physically in the same workplace. And we've also learned that, accessing documents and things of that nature is easier, and that there are tools that can allow us to do that, that we weren't aware of previously, perhaps just because we didn't have to be aware of them. So post-pandemic, there's a stronger general acknowledgement that meetings can be conducted effectively by phone or video conference, and that information can be exchanged quickly through email. Also, there are numerous jobs that in the before times were never thought of as being able to be performed remotely, that of necessity had to be performed remotely as a matter of course. For example, teaching. Maybe not the best example, since I know that that was very difficult for everyone, but you know, the point is just that there are a lot of things that we thought could never be done remotely, and we did it, and we made it work. So while the reasonableness of a request to telecommute turns on the nature of the employee's job, these days employers may be hard pressed to justify why teleworking is not a reasonable accommodation in offices that have been at least partially remote for many months. But there's no need to panic. The EEOC has issued guidance that is helpful to employers who don't necessarily want to let all of their employees continue to work remotely. Specifically, the EEOC has clarified that post-pandemic, employers are not required to grant the ability to telework as a reasonable accommodation to every employee that requests it. And that includes employees that had been working remotely for reasons related to the pandemic. The fact that an employer is currently permitting employees to telework because of the virus and is also excusing an employee from performing one or more essential functions of his or her job, mainly again because they had no other option, that can't be used against the employer. The fact that you allowed an employee to not perform certain functions of his or her job during the pandemic doesn't mean that going forward, those functions are no longer theirs. The EEOC has specifically stated that allowing employees to telework now does not mean that the employer permanently changed a job's essential functions, that telework is always a feasible accommodation, or that it does not pose an undue hardship, and that the employer, quote, has no obligations under the ADA to refrain from restoring all of an employee's essential duties at such time as it chooses to restore the prior work arrangement, and then evaluating any requests for continued or new accommodations under the usual ADA rules. The EEOC requires employers to look at the nature of the disability, and if the employee's disability-related limitation does not require working remotely, then there is no obligation to provide telework as an accommodation. Similarly, if an employer is able to address effectively a disability-related limitation with another form of reasonable accommodation that is at the workplace, the employer has the right to choose that alternative. So even though you don't need to panic, you still need to be careful because things are slightly different now. The EEOC is looking at remote work requests as an accommodation differently than it had done previously. Despite the reassuring guidance from the EEOC, employers who shifted to a remote work model during the pandemic will need to carefully consider each circumstance rather than, make a blanket denial of all continued telework requests or, essentially just restoring everything to exactly the way it was before and not really considering requests carefully going forward. The EEOC did state that the time an employee spent working from home during the COVID-19 pandemic could be relevant in determining whether the employee can satisfactorily perform all of his or her essential job functions remotely. The EEOC compared this time to a trial period regarding working remotely that employers should factor into their accommodation decisions post-pandemic. If the employee worked remotely during the pandemic, the period when the employee teleworked could be relevant information when considering the renewed request and likely will be reviewed by the EEOC and state administrative agencies in determining whether the employer could have provided the accommodation without undue hardship. Okay, enough about the ADA. Moving away from there, what do you do with a remote work request that doesn't relate to a disability? As I mentioned earlier, many employees may seek to continue to work remotely, either full-time or part-time for reasons related to childcare or productivity or convenience or comfort, among other things. So can an employer be sued in connection with granting or denying those requests too? And the answer is sure, of course you can. Specifically, it's important to be mindful of, first, potential discrimination claims, namely claims based on alleged disparate treatment. Think about an employee claiming that you denied her work from home request, but granted a similar request made by another employee, and that you did so because she's female or because she's over 40 years old, or based on her race or ethnicity. Another thing to worry about is retaliation claims. If an employee who has recently made a complaint that could constitute protected activity, For example, a complaint regarding harassment, or a complaint, which we've been seeing a lot, regarding the adequacy of the employer's COVID-related safety protocols. If an employee that has made a complaint like that requests to work remotely, you're primed for a claim that a denial of that request is retaliatory. So in order to avoid these types of claims, the best thing to do is create a written remote work policy, setting out objective criteria like seniority, disciplinary history, job duties, which guides the decision to grant or deny a request to work remotely. And you should be sure to document how each and every remote work request satisfies or fails to satisfy the criteria. Then in the event a claim comes along, you have the documentation to back up the lawfulness of your decision. Okay, what else? So let's say you've granted remote work requests, both as ADA accommodations and otherwise. Let's say you've actually granted every remote work request that has come your way. Surely no one can sue you now. Wrong, because the law is fun. What are some of the issues that could get you into trouble if you grant one or all remote work requests? First, ADA accommodations. Yes, other than remote work as an accommodation. Let's say an employee has a standing desk at work to accommodate back pain. That employee is also entitled to a standing desk while working at home, and the employer may need to make accommodation arrangements accordingly. Second, timekeeping and overtime. Non-exempt employees who work remotely, for them, remote work is still hours worked for purposes of wage and hour requirements like overtime and minimum wage. So make sure that your non-exempt workers actually record their time and do so accurately in the absence of the unusual clock in and clock out procedures. Best practice would be to have some sort of system in place. I've heard of employers using things like electronic timesheets or documenting hours via a personal or shared group spreadsheet, or sending emails to managers at clock in and clock out. Managers need to be diligent in reminding employees of their timekeeping policies. While working remotely, another issue, employee expense and reimbursement requirements. Employees in certain states, including New Hampshire and Massachusetts, are eligible for reimbursement for work-related expenses, which could include cell phones, internet, or equipment used in furtherance of the employer's business. So it's important to be aware of those laws and handle requests for reimbursement from employees accordingly. It might actually be great to have a policy in place and make sure that your employees are aware of it so that they know how to go about requesting reimbursement under the laws. Finally, coverage under federal and state employment laws. Even though remote workers aren't in the office, they're still considered employees and can be eligible for certain protections under state and federal workplace laws. So this can present a problem as the employee isn't under the watchful eye of the employer, but the employer is still liable for any employee misdeeds. And it can be more of an issue if the employer is subjected to claims in a state where the employee lives, but where the employer might not otherwise do business. So things can get complicated when the laws of other states will apply. Other misconduct concerns, again, these can result from lack of integration or supervision. Again, the best thing to do to combat things like electronic sexual harassment claims, the best thing to do is to have strong managers who check in with their direct reports frequently. Next, privacy. As more employers try to monitor off-duty and out-of-office conduct with computer and phone use searches, employees might push back with invasion of privacy claims. Again, having a written policy is really helpful for purposes of avoiding these claims. Employers are well advised to adopt a written policy addressing these topics and to recirculate the policy if you already have one so that employees are not caught off guard by monitoring activities. Next, data breaches. Remote work creates a whole host of issues relating to data security. I'm not going to get into that here because my good friend JP Harris will be covering that for you in detail in the next presentation. So finally, this isn't on my slide, but one more consideration is taxes. So if you have an employee that is working in another state, it's possible that there will be changes to the tax treatment of that employee's work. There are 22 states actually that impose income tax on the first day that non-residents work in their state. 17 states impose income tax on non-residents after a state-specific threshold, a certain number of days worked in that state is reached. Other states like New Hampshire don't impose income tax at all. So that's just another thing to be thinking about in the context of employees working in other states. Okay, so it looks like I have a couple of questions. Oh, and neither of them seem related to my topic. So actually, it's 9:30 and the timing is perfect. I'd like to introduce my partner, JP Harris, who is going to speak on a topic that's related to mine, and that is data security and safety with a remote workplace. Thank you.
Thanks, Megan. Hi, everyone. Good morning. As Megan mentioned, I'm JP Harris. I'm going to be speaking to you for about the next half an hour on data security and the new changes that have come to that landscape as a result of remote workers. All right, this is an overview of what we're going to talk about this morning. We're going to talk about sort of the new risks that everyone needs to grapple with now that we have more workers in more places, accessing your data from more data points. And we're going to talk about the emergence of new laws across the country that address privacy and data breaches. We're also going to sort of broaden folks' understanding and perspective on risk assessments. Whereas you may have conducted one already for your workplace in the more sort of traditional environment, we just need to kind of broaden that to encompass the remote workers that are going to be more of the norm, and how those risk assessments translate into policies and procedures. We're going to talk a little bit about cyber insurance and what changes you might need to consider in a remote work environment. And then we'll conclude with a discussion about third parties. We're bringing in more vendors to help us manage the remote workforce environment, and they are a particular vulnerability from a cyber risk perspective. So first, a little bit of data. This was published by the Federal Trade Commission, and the general theme of this is that in 2020 there was a huge uptick in cyber incidents. The FTC is focused largely on consumer-related incidents, but this data still applies and I think provides a cautionary tale for all of us. The FTC received over 2.1 million fraud reports just in the calendar year of 2020. And the dollars lost by consumers almost doubled in 2020 from the prior year. There were 1.4 million reports of ID theft, and that was twice the amount in 2019. And I'm sure there's a topic that many of you have grappled with, and that was the misuse of personal information to apply for things like unemployment insurance benefits. That was also up in a big way in 2020. So unfortunately, the dark cloud for all of us is that this is not going to get better anytime soon. There's been a lot of work in recent months to talk about a sort of a partnership between between governments and private industry to try to, because we're all sort of in this together. That trend will certainly continue. And I encourage all of you to figure out how you fit into that sort of eco space. But the risks are not going away anytime soon. All right, here's my first poll question. If I can ask Andrea to throw that up there for everyone. So the first poll question is, over the next 3 years, my company expects the number of remote workers to increase, stay about the same, or decrease as we return to the office. So this is trying to be a little forward-looking. Where do you think your company will be 3 years from now with respect to remote workers? All right, so there's a good mix here. Some industries, the remote working works well, and for some it doesn't work quite as well. So the slight leader in the clubhouse was decrease as we return to the office, but we've got a lot of expectation that remote workers will continue. All right, can we go to the next poll question, please, Andrea? This question gets to your security. So how confident are you, whether you're going to stay about the same or increase with your remote workers, how confident are you about the security of your systems? You're supremely confident, you're doing just enough to remain safe while staying within budget, or you're handing out tinfoil hats. Okay, 40% are supremely confident. That's a little higher than I thought it would be. The answer in the middle is the one we really want to try to talk about today, is trying to figure out the right balance of how much to invest in technology, what's your appropriate risk tolerance, what's your risk level, because you could spend, a huge portion of your company's budget on technology and training. And it's not a one size fits all solution. We want to really try to find the right balance point. So Andrea, if you can take down the poll of questions, thanks. All right, for years, it's been acknowledged that you can spend as much as you want on technology, but a significant vulnerability was sort of the human component, right? If you don't train your staff to recognize phishing emails or to refrain from emailing out all the W-2s for every employee in the company, if you don't train your staff to not use the same password for literally every account, you were just sort of undermining what you were spending on the technology side. But with a remote workforce, you actually have a new vulnerability. And that is all the other folks that are tapping into the home networks where your employees are working, right? This is the kids that have the home computer that's now a Minecraft server that's hooked up to the same network where your employee is also remoting in and trying to do work. You've got to think a little more broadly and try to really train up and arm your remote workers with the ability to sort of address the hygiene and security issues at home as well. So hopefully this sort of gets us all to broaden our thinking a little bit. What you have on the screen is some of the most common causes of a breach or security incident. And I just want everybody to pause and look at these for a little bit. You'll see that there's really kind of a global or holistic view that's needed to shore up as many vulnerabilities as possible. The stolen credentials or the weak credentials is a big one, right? Using the same password for your home accounts. Everyone that has a home router, it comes out of the box with an admin username and the password is password. And I don't know how many of you are confident that your employees at home have actually gone in and changed that password or update their firmware on any of the hardware at home. But there's a whole long list of vulnerabilities, and we just need to sort of reorient our thinking to shore up the defenses on all of these fronts. So if we have all these holes to close, I want everyone to pause and look at this list. These are the things, sort of the typical things that employers do. And I want you to ask yourself, which of these are actually more difficult in a remote work environment than they are when everyone's kind of in the office? And I submit to you, I think they're all more difficult, every one of them. I mean, training employees who are at home, it just requires a new method of delivery of training. And you really have a very difficult time actually ensuring compliance with that training at home. Enforcing network usage guidelines is much harder, as I said, when you've got people utilizing home network resources. Limiting access to data, I mean, that's out the window. You're actually trying to allow more access to your data, but you're trying to do it in a more secure environment. Encrypting data, well, now it was a little easier to encrypt your data when it was behind your firewall and it was on your side of the castle walls, if you will. Now you've got data transmitting and flowing all over the place as employees try to collaborate with each other. So you've got to deal more with encryption in transit, whereas maybe that wasn't really required before. Software updates, if you've got devices all over the place, you've got to figure out a way to manage and make sure they're patched and updated. Firewalls, it's just the same process to maintain your sort of workplace firewalls, but now you've got people at home that are using Windows Defender or they have their own firewall or security system at home, and how does that integrate with yours? Affording secure wireless access. Sure, we for the last several years, we've been talking about segregating your public Wi-Fi network, so when people came into your space, they could get access to the internet but not touch your stuff. Well, now we've got the home office environment times 20 or 50 of the number of employees that you have working from home. So the last one I just want to talk about too is don't forget about proper disposal of retired assets. If you've got physical devices and you have employees that are now sort of leaving your employ, this is a hygiene issue that's really important. But you got to address in a written policy sort of in advance what you're going to do with the assets that are being used at home. All right, the other issue, Megan touched on this a little bit, but if you're having difficulty hiring in this environment, or you've decided that there are productivity advantages to allowing remote workers, or you want to decrease your lease expense, right? Because now it's technologically easier to do that. You're just more likely to have employees scattered in other places. You don't need to hire somebody from New Hampshire necessarily. Now you've figured out the technological aspect, and you can hire somebody working in California. You can expand your horizons to find talent. But that means you have workers in more states, which means you're now subject to potentially more states' laws than you were when you were just kind of working through your brick and mortar facility here in New Hampshire. You also might have shifted from the to augment the delivery of physical services and goods from your physical locations to a more remote delivery environment. And that too means you're gathering data on consumers in geographic locations you otherwise wouldn't have touched before. So you have a lot more laws in play, and conducting a quick audit to figure out which laws apply to you is not the same as it was in 2019. But it's a necessary step to sort of figure out where your risks lie. You probably have the same statutory or regulatory exposure that you had depending on what industry you work in, but you might have new regulatory exposure because states are now passing their own privacy laws. California was the first and most notable. Virginia passed one. Florida had one under consideration that I don't believe passed. New York is working on one. New Hampshire had a bill that was almost identical to the California statute. So, and Massachusetts has for a long time had, its written information security plan regulations and those laws. But the state of the law that we're in right now is we've just got a patchwork of states all piecing it together. And you just need to know which of these laws apply to you. There is its own regulatory exposure for not complying with these new laws. Many attorneys general are empowered to enforce them, which includes civil penalties. And if there is an event and you have not been in compliance with these laws, you can expect a sort of piling on effect. In addition to all the notices that are required under these various states' laws, you'll have this sort of piling on of a fine for failing to comply with whatever laws apply in those jurisdictions. One note about the notices of a breach, one of the big drivers in the cost of responding to breaches is the number of states in which the affected individuals reside. So if you have a breach that deals with employee data, right, W-2s or health data, and you now have employees in 10 states as opposed to 3 that you had before, one of the big drivers in cost for that response is the number of states, because the notices are different in various states. In some states, you have to provide additional notice to attorneys general or other regulators. And just sort of figuring that all out just takes longer and it's more legal expense. And the same holds true if you have consumers or customers in more states than you had before. All right, I want to talk a little bit about risk assessments. So risk assessments these days is really kind of a 3-part team that supplements your staff. The 3 components, the outside components are there's a legal component, an information security component, and an insurance component. The legal component plays 2 roles. First, if you get legal involved, you can attempt to protect the entire process under a privilege. So if there is an event, you'd want to avoid having to disclose vulnerabilities, things you learned about as part of this process, but didn't address in time, those kind of things. So having legal involved at the macro level is intended to protect the privilege. But legal team also plays an important role in helping you memorialize policies and procedures to make you more compliant, to reduce risk as you move along. The information security component, and this is not your in-house IT staff or your managed IT service provider. These are specialists that address information security, and you don't really want your everyday IT folks sort of assessing themselves, right? This is an outside look to make sure you're doing the technological things that you need to do, and you just need a fresh set of eyes. Otherwise, it might be awkward for your everyday IT provider to raise their hand and say, yeah, we're not doing this part of it very well. But they they audit you for the types of data that you have, right? Personal information or health information, credit card information. They tell you how much you have, where it's located. They identify, this always happens, they identify resources that are still connected to your network that you have no idea. They identify weaknesses in upgrades and patching, those kind of things. And they identify for the legal team policies and procedures that should be modified or written in the first instance where they're lacking. And that's how the two kind of marry together. The insurance professionals, they play an important role too, because cyber insurance is not uniform. It's not like buying a property and casualty insurance policy. The market is sort of too new and too in flux. And so there's great variation between the policies you can get depending on what company you go with. And you don't, the legal and information security assessment will help identify the level of risk that you have and help you sort of tailor the insurance policy so that you're not underinsured and you're not overinsured. And we're going to talk a little bit about what's covered under a typical cyber insurance policy, but having an insurance professional as part of your risk assessment will just sort of make sure that whatever vulnerabilities you have, and you won't seal up all of them, are adequately covered. You'll see that there are sort of three distinct boundaries, right? The legal team, I couldn't tell you on a technical level, what you need to do for information security. And oftentimes you find the information security folks are hesitant to draft policies and procedures for you. But the upshot of all this is that you come away with actual procedures, things you can implement on a daily basis to keep you on the right track. All right, so here's a little bit about the work product from the policies and procedures perspective. It's sort of the offshoot and comes out of the risk assessments. Again, training your staff is vital. And so having a plan, there's a lot of outside resources you can bring in to touch on different aspects of the training. And keep in mind, you've got to deal with sort of the technological part of the training, which might extend to home environments, right? You've got to sort of arm your folks about learning how to get into the admin privileges on their router at home, or how to properly utilize VPN as opposed to less secure access points. So that kind of training just sort of needs to be rethought of in the remote work environment to make sure we're actually reaching into people's homes. Network and device use policies also are kind of an offshoot or a byproduct of the risk assessment. Again, extending to home office, making sure people know not to use their home, their personal computers if you're supplying them with a computer, to not save things on thumb drives and just leave them around the house, to not save things locally. You got to deal with the fact that you've got, or at least in 2020, you had a second grader trying to do remote learning that had his or her own access to the environment while your employees trying to work too. And then there are these very robust privacy policies and programs that are now being more the norm and being required as states start to implement more laws like the ones in California and Virginia. Again, the risk assessment is intended to determine which laws apply and come to a consensus within your organization about the level of compliance that you desire. It is impossible to comply with literally every component of every privacy law, and it's not necessary. But on the other hand, you've got consumers now who are getting more used to having their own rights. They have the right to be forgotten, right? The right for you to delete data about them, or the right to correct data that you possess about them. And if you don't have a plan to, address those requests when they come in, you're going to have problems sort of working in the new business environment that your consumers are all getting used to, but you're also going to have some regulatory risk. So from the technical side, the risk assessment, right, this is the part that the information security folks kind of build in, but they make sure your hygiene is solid from sort of password management, multi-factor authentication, like patching and updating schedules, limiting access to data, handling encryption, disposing of assets. And the good ones, the good risk assessments, what they do is they prioritize. They identify your immediate risks. These are the things you have to close up right now because they're a significant vulnerability. and then they put you on a path for a couple of years. You don't need to drop everything, invest all of your available resources in cash, into beefing up every single aspect of your network all at once. It's just to put you on a plan, a multi-year plan that you revisit, at least annually to see sort of where you are and whether adjustments need to be made as technology advances. But it's just a way to sort of manage risk as time moves along and put you on a path that is appropriate for your risk tolerance and your compliance needs. But keep in mind that the sort of theme of this half-hour presentation is your technical program needs to extend to the home environment if you're going to continue to have people working from home. All right, on the insurance side, you may know that when you apply for cyber insurance, let me pause here and say that if you just have kind of a quote unquote free tack on cyber insurance as part of your general commercial liability coverage, you're probably underinsured. You really sort of need to consider having a standalone cyber policy. And in order to get that, the underwriting process requires you to fill out this rather lengthy application that is kind of like a little mini risk assessment. It's to ferret out what kinds of protectable information that you have, how much of it, how many people have access to it, and what you're doing to safeguard that information. And the better your answers are on that, the lower your premium is. So that's another reason to undergo the risk assessment. It actually translates into savings, not only because you avoid or minimize the risk of incidents, but it does reduce your premium on your cyber insurance. But what you need to know is it's just like every other insurance application. When you make representations, that application becomes part of your policy. And if you have an incident and the carrier looks back at what representations you made as part of the application and finds those to be inaccurate, you actually risk blowing your coverage. So I raise this because you may have made representations as part of your application that are no longer quite as true when you've got 50 employees working from home. And so this risk assessment will not only make sure you have the right kind of coverage, but it'll make sure you're still living up to what you've represented in your application. So here's an example of what's covered under a good cyber insurance policy. First of all, if you have an incident, you'll get access to some of the country's leading information security forensics specialists. They swoop right in. Part of my job is to sort of quarterback that, to keep that under the work product privilege, but they swoop right in, they scan your systems, they determine what happened, they help preserve evidence, but they get you back up and running right away from a business continuity perspective. The policies also cover the legal costs of supervising this whole process and providing notice to those, if there actually is a breach, to provide notice to those that need to get notice. They also cover ransomware payments. So if you don't have access to cryptocurrency, your insurance company will. So they'll cover ransomware payments. There's some coverage in certain instances for regulatory defense and penalties, payment card liability. If you have to offer credit monitoring, for example, if there's a breach of someone living in Massachusetts and the Social Security number is involved, you have to offer for credit monitoring for free. These carriers will give you access to these terrific products offered by the credit bureaus typically, but they cover that cost for you. If you have a really disastrous event, you can get PR professionals involved to help you message. And also, if you really need to ramp up with call center to handle the flurry of phone calls, the insurance companies cover that too. And then hopefully you don't have any claims from people who would say, somebody took out a new loan in my name as a result of your breach, but the policies do cover third-party liability claims. And another big one is funds transferred due to fraud. We've had several clients that have had forged documents sent their way and redirects ACH payments, so you can get some coverage for that too. So again, there are different levels, different deductibles. Some policies exclude some of these things. So this is why I recommend you go through the risk assessment process. Now, do cyber insurance policies cover the remote workers? And every lawyer learns that the answer to every difficult question is it depends. And that's true here too. So I'm going to speak in generalities, but you need to really consult your policy specifically. Most policies do not differentiate based on location of the asset. So if it's, the question really is it a company resource? Is it somebody and a device that is authorized to access your infrastructure? But again, this sort of ties back to if you've made representations in your application that, you know, we have only so many devices and they connect to us in this manner, but now that's not true anymore because you've got people connecting from home. You just need to check on that. There's a little tip here at the bottom. You want to try to make sure that your policy language matches your reality. Make sure that if you can get language that extends to employees and independent contractor devices that are authorized to access your network. All right, we're going to talk for the last couple of minutes about third parties as we move to a remote environment. And this was a trend anyway, regardless of this remote environment. We were bringing more third parties into our data. Cloud providers are the best example. There's a real benefit to moving your data to the cloud for productivity and access purposes. You are offloading or outsourcing some of the security requirements, keeping less of your data in-house. But the upshot of that is you just have more third parties that have access to your data. And my open question to you all is, do you know who bears the risk of a security event? Do you know what they're doing to protect your security? Do you know what they have for insurance? If you don't know the answers to these questions, you're not alone. We are now moving to a new world where you're under an obligation really to vet vendors. If what you're going to do with consumer data in particular, or your employees' data, you have an obligation if you're going to share that with others to know what it is they're doing. What I encourage all of you to do is have a vendor management policy. It's not enough to just have your business folks decide on this is the best vendor for us because it has all these bells and whistles, or we get to do these things. You have to factor into that assessment the level of security being provided by these third parties. It has to be part of your criteria. So have a written plan to do that. You want to test things like how frequently will they report their audits, their risk assessments, and get all this information as part of your consideration of the deal. But once the deal's signed, don't forget, you've got to monitor these. It's a 3-year contract. You need to monitor these folks. And I've given you some hints here about some clauses you want to have in your contracts with these third parties. You want them to make specific promises and warranties about the level of security they're going to provide. You need to address indemnification. Who's going to bear the risk of loss? And keep in mind, there's going to be a sharing, right? You're going to have some responsibility for protecting the data on your side, and they're going to have some responsibility. Be careful about limits of liability clauses. I'll bet you $1, the first draft of these contracts will have a limit saying, under no circumstances is this provider liable to you for anything more than what you've paid them in the last 12 months. Well, that may not be good enough, depending on the risk associated with it. What's their cyber insurance look like, and can you be covered under that policy? And you want to get immediate notice of every incident, not just breaches. If they have any kind of whiff of a problem that affects your data, you want to have notice of that immediately so you can make your own decision about whether notices are required. So that's a quick run through of some of the key contract clauses you should have in your contracts with your vendors. So we'll pause here. We have one question so far. It says, do you recommend hiring a company like HackerOne to check our systems for vulnerabilities? They have hackers that try to get into their system. So this is penetration testing, which is very popular. It is part of plans that many companies are doing. In fact, some companies are offering bounties. They will offer $500 to the person who can get into our systems and share how they did it with us, so that we know we can patch that vulnerability. It's not right for all companies, right? They're not the cheapest endeavor, first of all, and that's why I think a risk assessment is important, so you can figure out how much data you have and what your risk really is to determine whether this is warranted under your circumstances. But if you're in the health industry, for example, this is pretty close to being required. If you have a lot of credit card data or a lot of Social Security data for some reason, you'd want to give this some consideration. Having it done under the control of a lawyer, I think, is a good idea because, again, we're trying to cloak some of this work under a privilege so that if there is an incident later, you don't have to turn over the report. But talk to your IT folks. If you've got an information security provider in your life, get their opinion on it because it might be right in your circumstance. And right at 10 o'clock. So thank you very much. And I'm going to turn it over now to Michael Lambert, who's going to talk to you about protecting confidential information and trade secrets. Thank you, everyone.
Thanks, JP. If nothing else, you're right on time. My name is Michael Lambert. I'm going to be talking today about protecting confidential information and trade secrets. One of the many challenges that you may have experienced in 2020 is adapting to a workplace that is no longer centered on an office headquarters. We've seen, the first hurdles were coming to grips with a significant number of employees working from home, and then making sure that each employee had the home infrastructure in place to quickly adapt and contribute. And once these were set up, employers continued to drive employees to do their job and to deliver opportunities and make sales and come up with results. But as a result of this, there's been a decentralization of institutional information, knowledge, know-how, and confidential information. There's been no central hub, no single place of employment, no repository for company information. Instead, employees have been sending information, emails, texts, attaching sensitive information and correspondence and analyses just as a function of having to work remotely. Many of these communications likely contravene best practices for maintaining confidentiality and secrecy of important business matters and may violate company policies. We've seen through some of the polls today that many companies have learned and are learning that the work from home model necessitated by the pandemic or some variation of it may be here to stay. I don't know if any of you saw the Wall Street Journal article this weekend, but they had an interesting article that did a survey of 2,000 employees, and 42% of the employees working remotely said that if their employers didn't make the work from home option permanent, they would find a new job that did. And that's somewhat consistent with some of the poll numbers we saw today. What we've learned is what was once viewed as suboptimal, having employees working from home, has proven in a lot of cases to be preferred by the employees. And many companies have learned that the productivity of these employees has increased, not decreased. So what were once these emergency measures put into place 14 months ago may in some form or fashion become permanent as companies adapt and move forward as we come out of the pandemic. So what does this mean for your company and your need to protect valuable business information? First, we're going to take a look at what categories of information are protectable under the law. First is trade secrets. Business information is valuable because it's a secret, and it's a secret and protectable only when the employer uses reasonable efforts to preserve its confidentiality. Trade secrets include such things as curated customer lists and information, financial information, strategic plans for products, formulas, and really anything that advances your company's competitive position. State and federal trade secret laws define a trade secret as something that derives independent economic value from not being generally known to the public or readily ascertainable by legitimate means, and which is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. The claim that something is a trade secret show proof that you use reasonable steps to protect that information. This includes, at a minimum, the imposition of reasonable non-disclosure agreement with anyone, every employee handling sensitive information. Confidential business information is another category of information. Certain information may not rise to the level of a trade secret as defined, but might nonetheless be valuable and worthy of protecting. Would you want your competitor or anyone authorized to view it to see your quarterly performance or projections? Probably not. If you have legitimate business interests in protecting this information, you should take steps to protect it. Let's talk for a minute about customer prospect and supplier goodwill, as well as employee relationships. Most companies spend a lot of resources developing relationships that benefit the company and that are invaluable to their company's success. The fact that you can't lock goodwill or relationships in a safe or encrypt it so that it can't be taken doesn't mean that it's not valuable, and certainly doesn't mean that it can't be protected. So how do you go about protecting this valuable, proprietary, and sensitive information, whether it's a trade secret or confidential business information or goodwill, when your employees are scattered and have been working from home and may continue to be working from home for the foreseeable future, or maybe even permanently? Communicate, educate, and legislate. Communication with employees about making security and confidentiality a meaningful part of their daily lives, and establishing the importance of care, caution, and confidentiality is really important. Messaging to employees that even though the environment has changed, they're handling confidential company information and property and must act with care. Educate your employees on the purposes of confidentiality, the best practices for maintaining confidential information and protecting trade secrets, the pitfalls and potential problems they face, and the technology and resources available to assist them meeting the company's goals of protecting trade secrets and confidential information. Finally, legislate. I chose the word legislate primarily because it rhymed, but also because it goes to the issue of company policies or rules. Does your company have a trade secret protection program? Is it customized for a remote workplace? Have you put into place internet, email, and text messaging policies? Policies like this are a critical component of the reasonable efforts that are required to claim trade secret protection for confidential information, and a prudent practice in keeping competitive information out of the hands of competitors. In most companies, not every employee needs to have access to all company information. It's important to limit or continue to limit access to company information and trade secrets to employees who really need it to do their job. Use and update passwords and password protections to access company networks, and limit access to specific networks, drives, or segments to need-to-know personnel with authentication for every login to the network or segment. JP hit on some of the cybersecurity issues, but the point here is really, if you can, don't skimp on the IT here. The days of protecting critical business information by having it in a locked filing cabinet are gone. It's really necessary to protect this information with a robust cybersecurity tools and practices. At the very least, mandate that employees working from home have certain basic security in place, such as password protected Wi-Fi, employer approved antivirus and anti-malware software. Employers should require that employees change their default passwords on their home routers and use different passwords for home systems and data than they do for work-related access. Encrypting particularly sensitive information that is sent to groups and customers and prospects, signaling to the users and the recipients that they are sending and receiving sensitive information. Next, I want to talk about taking care on onboarding and departing employees. Employee mobility remains the biggest single threat to the competitive position of any company in any industry. And we know that from recent surveys, there will be unprecedented numbers of employees changing jobs in the next year. creating risks that companies will have employees that had access to a broad universe of confidential and proprietary information leaving and possibly taking that information with them. So let's talk about how to protect that information from misuse or misappropriation through contractual agreements and best practices. Some companies have a formal employee mobility and trade secret protection program, and others rely on a more informal practice of using contractual restrictions. But in either case, you should take care on both ends of the spectrum, both onboarding employees and dealing with departing employees. Most companies focus only on the departing employees, but companies face liability from a new employee's former employer if they fail to protect, to properly screen candidates and applicants. Some questions and issues that should be addressed during the application and onboarding process. I imagine most companies have a checklist for this, but these are some of the issues and questions that should be asked on the onboarding process. Have you made it clear from the outset that your company honors the reasonable and valid post-employment obligations? Have you made it clear right from the outset that the applicant should neither bring nor use any confidential information from a prior employer? Naturally, this is particularly important if the applicant worked for a competitor or in the same field or industry. Does the applicant have post-employment agreements that restrict or disable their ability to work for you? Are those agreements valid and enforceable against the employee if she joins your company in the anticipated roles? Does that agreement include a provision requiring return of company property? If the applicant has already departed, have you confirmed that they've carefully honored that obligation? Does the applicant possess knowledge that their former employer might consider confidential and at risk in the new role with your company? Resolution of these questions and others in advance of making an offer can identify potential problems and avoid claims from and litigation with a new employee's former employer. Now let's turn the focus on departing employees, which pose different and quite frankly more risks to your confidential information. The departure of an employee, particularly to a competitor, opens a window to the loss of important confidential information and trade secrets, as well as valuable goodwill residing in that departing employee. This will certainly be complicated if that employee has been working from home. First, going to address some practical measures that you should consider taking, and then discuss use of restrictive covenants. Again, I'm sure most of you have a checklist for the steps taken when dealing with a departing employee, but just to cover a few of the things that hopefully are on that checklist. You should be evaluating a departing employee's recent work, recent access, and download activity. An odd benefit of the remote access that's been happening with work from home employees is that this information is documented in a forensic trail and it's easy to follow. When I first started practicing law, lawyers would hire private investigators to follow departing employees to see whether they came into the office after hours or on the weekends, to find out what they removed from the office, etc. That's probably not necessary now, but following the electronic trail of information is important and should be done. The checklist should also include shutting off access to email and other internal and external communication systems, placing automatic notifications on email and cell phones, as well as sequestering company-owned and issued laptops, phones, and other devices so that evidence of activities in the immediate term can, if necessary, be reviewed and preserved. Obviously gathering all company property, and then conducting an exit interview, if possible. That would include an explicit discussion of any post-employment obligations and a description of the categories of information that the company considers confidential, proprietary, and trade secrets. That brings us to the discussion of restrictive covenants, which really could be and has been the subject of a seminar all on its own. I want to highlight some of the issues regarding the use of restrictive covenants as part of a program to protect vital business interests. You'll note that I intentionally use the broad descriptor restrictive covenants and not non-compete agreements. For years, the term non-compete agreement was used to identify all types of post-employment restrictions. The problem is that this creates confusion and conflicting messages about the enforcement of different types of post-employment restrictions. The fact is, non-compete agreements, which are agreements that limit an employee from working for a competing company, usually for a period of time within a geographic area, is one of several types of post-employment restrictions, which together are more aptly referred to as restrictive covenants. And as we found out over the past 15 or 20 years, non-compete agreements are universally and heavily disfavored by courts. In most circumstances, New Hampshire courts will not uphold non-compete agreements that prevent a former employee from working in the industry. While there may be narrow circumstances where they will be enforced, the overwhelming majority of non-compete agreements are not narrowly tailored to protect a company's legitimate business interests. And there are other less restrictive means of doing so. So calling restrictive covenants non-compete agreements confuses the issues and unfairly and improperly taints the other equally effective but less restrictive means of protecting your legitimate business interests. Non-solicitation agreement is a type of a restrictive covenant that prohibits former employees for a period of time from trying to divert certain clients and/or employees from your company. This has become an effective means of protecting the relationships and goodwill that a company has developed. You have to take care, however, to have a restriction that is narrowly tailored to protect your company's legitimate business interest. If an employee worked closely with only 5 out of your 25 accounts, it's unlikely that a court will enforce a non-solicitation agreement that prohibits that employee from soliciting the business on behalf of a competitor from the 20 accounts he or she had nothing to do with. The final type of restrictive covenant are confidentiality and/or non-disclosure agreements. Employers frequently require employees to sign agreements with non-disclosure restrictions, which prevent the former employee from divulging or utilizing employers' confidential information. These types of agreements are largely prophylactic measures that you can use to highlight the importance of confidentiality with your employees and use as evidence of your purposeful and reasonable protection of sensitive business information. While these agreements do not restrict employee mobility or provide a basis for prohibiting an employee from going to a competitor, they do give you a basis for warning a departing employee of their contractual obligation not to share or disclose information. And they give you a remedy against that employee and their new employer if they do violate that confidentiality obligation. It's important to remember that restrictive covenants are one piece in a plan to protect confidential information, and that implementation of the plan is as important as the actual contract or restrictive covenant you use. You can have the best agreement, but if you don't present it to the employee at the right time and under the right circumstances, and you don't take other reasonable measures to protect sensitive company information, it will literally be worth the paper it's written on. Even worse, you could expend resources trying to enforce a restrictive covenant only to have a court determine that the restrictions are not enforceable. Consistent implementation practices is key. In addition to advising prospective new hires that they will be required to sign agreements with post-employment restrictions and giving prospective employees a copy of the agreement at or prior to the time of the job offer, you should also give incoming an existing employee's time to review the agreement carefully with counsel at their expense if they choose, making sure the new employees sign and return the agreement before commencing work. I know it sounds severe, but planning for the departure of new hires from day one is the best approach to protecting your company's valuable assets. Many of you may have some type of employee mobility and trade secret protection plan. If you don't, you should consider having one. It will help lay out the checklist for onboarding and departing employees. It will help the practice and making a consistent practice with respect to the use of restrictive covenants. It really solidifies the efforts your company is taking to protect its confidential information and will help you establishing the status of trade secrets if those are applicable. Finally, restrictive covenants are not a one-size-fits-all. So companies thinking that I've got an agreement and we've had everybody sign it, we're good. That's probably a mistake. What may be necessary to protect a legitimate business interest with one type of employee will not be enforceable against an employee that has a different job responsibility or access to different information. It's important to spend some time realistically assessing what legitimate interests are at stake. Identify those employees who need to be restrained in some way in order to protect those interests. And it's not going to be a cookie cutter one size fits all. Don't be lulled into a sense of security simply because you've checked the box that certain employees have a restrictive covenant. Things change, and if your restrictive covenants don't also change, they probably will not afford the protection you were seeking when you had the employees sign the restrictive covenant. If an employee's roles changes or the responsibility or title changes, it may be necessary to have them sign a new restrictive covenant. Moreover, the law is constantly changing, both by statute and the way courts interpret the agreements. The law is also very different between states. Courts in Massachusetts and New Hampshire used to be very closely aligned in how they treated non-compete agreements and restrictive covenants. Both states now have different statutes that address different aspects of the use of these agreements. The best practice really with respect to restrictive covenants is to periodically audit your use of them and determine whether changes or updates are necessary. When it comes down to it, it's not prudent or reasonable to expect that courts today will simply take an overly broad agreement and pare it back to make it enforceable in some respect. Courts may simply refuse to enforce any restriction if the judge determines that that you overreached, particularly during a pandemic or in the flurry of employee mobility that's expected to follow. So that's the nuts and bolts of restrictive covenants. Again, it's a detailed area of the law. There's no one size fits all. People often ask, well, are non-competes enforceable? Well, it's like asking, does food taste good? The answer is yes, sometimes they're enforceable. No, sometimes they're not enforceable. And it really depends on what information you're trying to protect and how you go about doing it. So thank you for your time. Let me see if there's any questions. And I don't see any. So I appreciate your time today. And if you do have any questions, my information is there, and please feel free to reach out. Thank you.
Thanks, Michael. That was terrific. I truly appreciate the insights of Megan, JP, and Michael, all very busy lawyers these days, especially these days in COVID, with the many different things going on, and whether it's dealing with workplace issues or in the area. I mean, each of them are litigators, but it's also dealing with just how the law has evolved in just in 1 year and their adaptability. So I appreciate their time and their insights on everything from remote work to data security and, of course, dealing with restrictive covenants. And I think we'll see more in the year and to come and beyond with regard to changes in this area, so stay tuned. And in that regard, first of all, with regard to credits, you'll see the information here with regard to the SHRM credits available and the HRCI credits available for this program. And I also want to just remind you that you need to register for our the second half of this program this Thursday. It's free, as Kelly said. Just register online at sheehan.com. And we're going to have Karen Whitley talk about the American Rescue Plan and what's involved with that. Liz Bailey talking about recent developments in labor relations and labor law and what we're likely to see in the next year or two. And Brian Bouchard talking about OSHA workers' comp issues along with long haul COVID. And then we wrap up with what's on the horizon with regard to legislative and regulatory changes that are in process now or we're likely to see. So lots coming along. But in the meantime, just thank you to our presenters. Thank you to Kelly, Liz, and Andrea for the back of the office. We couldn't do presentations like this without them, and they've done a terrific job in that regard. So we look forward to seeing you on Thursday. Do not forget to take the survey, the evaluation at the end of the presentation, because as Kelly said, that helps us as we plan future events. Thank you so much. Enjoy the day, and we look forward to seeing you again on Thursday. Thank you.